So I wanted to take some time this evening and talk about the idea of trial as a last resort. That's one of those things that you see on a lot of advertisements for different lawyers. And if you talk to lawyers, that's a common phrase that they'll throw out there. It's not wrong, but I don't think it's quite right. And here's what I mean by that. Not very many cases go to trial. And this idea that we should save trial for cases where we're unable to resolve it by any other means, I think contributes to that. And I think that's by design in many ways. You know, my experience has been, as a defense attorney, shockingly, that most people are absolutely terrified to go to trial. Many of the cases where I'm trying my best to convince my clients to go to trial because they've got such a good defense, it's like pulling teeth to get them to go to trial. And ultimately, it's not my decision, right? Ultimately, it's the person who's accused of the crime. It's their life. It's their decision. So we wind up in a situation where people are scared of going to trial in the same way that people are scared of public speaking, right? You're scared of having a whole group of people looking at you, judging you the whole time. Scared of the consequences of going to trial, because when you ask your lawyer, hey, what am I facing? We'll tell you, well, this is what this judge normally does, but also they can do up to this, which is some, insanely aggravated amount of jail time or prison time. And the third part of it is the system itself, which grinds you down on your way to trial. And what I mean by that is for people who are out of custody, it's a long period of time to get to trial. Colorado has a 6-month speedy trial right, meaning the DS take you to trial within 6 months. But 6 months is a long time, especially for somebody facing a minor charge. And a lot of things happen in 6 months if you've been accused of a crime. A number of my clients are dealing with domestic violence charges, and a number of them are in the military. Well, if you're in the military and you're dealing with a domestic violence charge, whether or not you've been convicted doesn't matter so much for them if the process is dragging out too long, right? Even if you said, no, I pled not guilty, I'm going to contest this all the way. If you have to make them wait too long, they'll start moving you out because they can only have you be without a firearm, especially if you're in a combat role, for so long. And the same thing works for people who are employed by regular companies. I mean, your background check comes around and you've got this charge. Well, then they start looking for other people to, move up to that next promotion or to move to that new job, or when they're, making a choice of who they got to let go, you're an easy target. So this time period, it may not seem like a ton of time or may not statutorily be like a ton of time, but for my clients, it's a significant amount of time. And it's far worse if you're in custody. If you're in custody and you've been unable to post bond or you've got some kind of hold that prevents you from posting bond, well, then that feels like an eternity, especially if it's a situation where you've got an offer on the table to make this all go away and you can go on probation, you can get out of custody if you just plead guilty to this charge. So those are the kind of things that I see that break people down and encourage these plea bargains. And so the reality is trials become almost this sort of luxury, right, for the people that are super determined, that have the resources to stick it out all the way through, and for people who are not super risk averse, right? Those are the people that end up sticking it out and going all the way to trial. So the question is, is that appropriate? I have reservations about that. The way that our system was set up was so if you were accused of a crime, you could take that accusation to the members of your community and have them decide the truth of it. That's a big departure from the systems that existed beforehand, where a king was the arbiter of what was true or not true and what the penalty was. We've taken that role out of the hands of the executive and we've given it to the legislature, these judges who are impartial and members of the community who act in that same role and hopefully have that same amount of impartiality and shared life experiences and that kind of stuff. And we've decided that they are the better mechanism for deciding what is true. Because that's what jurors do, right? Jurors decide what is true and judges decide what the penalty is. So I don't think it's a good thing that so many of these cases plea out. And what I mean by that is the overwhelming number of criminal cases plea out. I have some statistics that I think I can share that might be, a little bit illustrative of that principle. So one of the things that El Paso County does a really good job at is they keep very good statistics on the criminal cases that are filed and the ones that go to trial. I can put a link on here, but it's da4colorado.gov, and there's a statistics section there. So by way of illuminating that point, when I'm recording this video, it's November 28th of 2022, so towards the end of 2022. If you search the DA statistics, you can see how many cases have been filed as of today's date. And so currently we're looking at 23,657 felony cases filed. Okay. You can also go down and see how many of those cases have gone to trial. And so if we scroll down, we can see that currently they have done 326 jury trials and 15 court trials. So jury trial is a trial to a jury. Obviously, court trial is a trial to the judge. It just means that the judge makes all the factual determinations. Court trials are far rarer than jury trials, but they do happen from time to time for strategic reasons. So that gives us a total of 341 trials. Yeah, so if we just do some real simple math there, and we take this number of 341 trials, and we divide that by the total, we wind up with a figure of 1.44 trials on average. So that's really tough statistic when you look at it. You got to ask yourself the question, do you really think that the DA is getting it so right so often that only 1.5% of the cases that they handle should go to trial, right? That those cases are either pled improperly or not dismissed to the point that they should go to trial. I think I just don't think that that's true. I mean, that hasn't been my experience, especially when the overwhelming majority of cases filed end up being low-level charges that don't even go through the review process at the DA's office of having a filings department determine what charges should be filed. So I'll give you the numbers on that as well. So currently in 2022, we're looking at 7,781 misdemeanor cases filed. Then there's traffic cases, which also fall into that same purview of county court. 9,362. So the overwhelming amount of cases filed go through county court. Well, that means that they're not reviewed by a filings department for accuracy, right? That just means it's a cop that writes a person a summons and then some district attorney handles it. Compare those two numbers with, roughly 16,000 cases going through county court so far in 2022. The number of felony cases filed so far in 2022 is 5,678. So what that means is that more than double the number of cases are filed into county court by a police officer, never having been reviewed by the district attorney's office, than the felony cases that are filed. So, when you look at that number and you go, okay, well, there's not even a review process for those cases to see if they were properly charged, and they're winding up, in the county court division. Do you really believe that 1.5% of those cases should end up going to trial, or should it be a higher number? The reality is that the system is not built to handle a higher trial caseload than that for any division. I mean, so the way that most misdemeanor divisions in El Paso County work is they end up doing trials twice a week. So, they'll either have like a Monday, Wednesday trial docket, or a Tuesday, Thursday trial docket. And if you've ever had a case set for trial there, or if you're an attorney, what you'll find out is these county court divisions stack these cases, 10, 15 trials deep. And the same thing happens in felony courts too. They have less trial days, typically 2 trial days a month rather than 2 trial days a week. But those still stack those trial days, 10, 15 cases deep. That means that if you're set for trial on a certain day, you have no idea if you're going to end up going to trial on that day, or, if a higher priority case is going to take over and you're going to get bumped to a later trial day. And that's a situation where we're only dealing with 1.5% of cases going to trial. Imagine a situation where only 20% of cases went to trial. And I still think that's a, pretty low number, for 20% of people charged with the crime to exercise their constitutional right for trial. But imagine if that happened. I mean, the system could not possibly handle it. We wouldn't be able to hire enough judges. And we wouldn't have rooms to fill them. And frankly, we wouldn't have enough people in the community that we could get to do jury service on that number of cases. So the reality is that the system, it has to exist this way. Maybe in the aggregate, that's just the way it is and we have to live with it. But what does that mean for your individual circumstance? Well, I think that means that it's the wrong way to think about it, to think about trial being the last resort. Should you engage in the plea bargaining process? Sure, absolutely. You should always, if the DA has a plea offer, you should at least listen to what they have to say. Sometimes they can be incredibly favorable, right? I mean, I get a number of plea offers that come through, which is, look, do a class and we'll dismiss the case or something like that. Well, okay. I mean, it's a 2-hour waste of my time kind of thing, but fine. If that's the trade, then that's reasonable. But also I get a lot of clients that just aren't guilty. And if you wind up in a situation where you're walking into a lawyer's office and you're saying, hey, I didn't do this thing, then trial shouldn't be the last resort. Trial is the first resort. And that needs to be the approach taken from the first meeting in all the way up until jury selection, is that, hey, we're not planning on this case pleading out. We're going to go to trial and we're going to stick it out until we're part of that 1.5% who's going to exercise our rights and hold the DA's feet to the fire and present the witnesses that we have that the police didn't interview that say a different story than all of the ones that, the complaining witness brought in to talk to the cops. It requires determination and effort and an understanding of the process and a steadfast willingness to stick it through until the end. Probably the thing that concerns me the most about that statement is it implies that trial is something to be avoided. Maybe that's the best way to look at it. If you come at your case from the idea that trial is the last resort, then I think de facto what you're saying is, I don't want to go to trial. I'm going to avoid trial. I'm only going to go to trial if I'm forced into it. And that is the wrong way to be. If you look at the case and you see that you have a winning hand in that case, either the cops didn't do their job and get the evidence, or the evidence does not support what the DA is saying, or no juror in the world is going to buy this one theory that the DA has that just doesn't fit with the evidence, then that case needs to go to trial. And if you come at it from this idea that we're going to do everything we can to avoid trial, well, then you're going to end up pleading guilty to something you didn't do. And that's the situation that most people find themselves in who enter into the criminal justice system who didn't do anything wrong. This idea that, well, I'll just take this thing so I don't have to spend more days in court, or, gee, isn't that scary? What the penalties are. I think I'm going to take the deal and avoid that. Those are conversations worth having, but the simple reality is that a trial is not a sure thing for anyone, but that includes the DA. And there's many, many times that I've gone to trial that a jury has surprised me. And if you're winding up in a situation where the DA is not giving you a benefit to your bargain, then just taking a trial to make it go away is the wrong decision. You need to stick to your guns And you need to trust your community that at the end of the day, they're going to see this case for what it is, because most people are pretty rational, right? And they don't want to be a subject to some, defective investigation or some ridiculous charging theory that the DA has. It's a situation where things were just done wrong. Jurors don't appreciate that. And that's a good thing. Now, it doesn't mean that you shouldn't take a plea deal if you're charged with a crime. I mean, that's what lawyers are there for. They're there to talk you through the pros and cons of the plea offer, and ultimately it's your decision. But understand that our system isn't set up, at least originally, our system wasn't intended to be a system of pleas. It was intended to be a system of trials. And what's happened over time is that you started with a world where there was only, originally there was only 5 felony charges, and that was really all there was. They had a few municipal charges and that kind of stuff, but they didn't carry significant penalties. But over time, more and more charges have been added to criminalize more and more things. And to handle that volume of this overcriminalization of conduct, we've built a system that's, this assembly line process of grinding people through it into plea bargains. And the last thing is this idea that, well, if you've got a good enough defense, then the DA should just dismiss the case before trial. And that's true, and it's awesome when it happens, but the reality of it is that if you're defending a case, you have probably the biggest advantage that you're ever going to have as a lawyer, and that's the one-sided discovery rules that we have in Colorado. What that means is that the DA has to provide you with their evidence, but you don't have to provide them with your evidence. So you have the element of surprise in a lot of these situations at trial if you don't turn over the evidence that you have. So, what does that mean? What's the significance of it? Well, it's like this. Say that you've got you've been charged with a crime, but your next door neighbor was a witness, right? But the police didn't interview them for whatever reason. They've got a long day. They're turning over these cases quickly. Your friend had left and gone to the grocery store and they didn't follow up. I mean, whatever, a number of reasons. Well, that person is a tremendous witness for the defense. So the question then is, okay, well, I got this great witness. Do I tell the DA about this witness? If you've got a great DA who's understanding and appreciates that kind of forthrightness, then maybe you do, right? Maybe you can tell them about it and the DA look at the case and go, okay, this person completely blows up my case. I'm not going to take this all the way because I know what's going to happen. Awesome. But that's not always the case, right? The other way that can break down is you tell the DA about this witness who's super great for you, and the DA gets their statements, and then they ask their witnesses about those statements, and then all of a sudden their witnesses change their tune to be more in line with what that other person said, or to address whatever inconsistencies they have with that other statement. Basically, the DA can take that information and go back and consciously or unconsciously fix their case based on that. And then you lose the element of surprise. So just because you have a powerful piece of evidence does not mean that that piece of evidence should be used in the pretrial process. Sometimes that evidence needs to be produced at trial when it's too late for the DA to go back through and correct their witnesses' statements or to change their theory. Once they've made the mistake and they've gone down the wrong path, thinking that there was nobody that could stop them, then that's when it's time to produce that evidence. The most powerful weapon that we have on the defense is our ability to cross-examine witnesses. And that witness stand where they're sitting there without their phone or their laptop or their attorney, when they just have to answer the questions asked by the defense one after another without the ability to change the topic or to squirrel away or to research their answers. That's the ability to get to the truth. If they're lying, they're going to run into a web of lies and constant contradictions. But if they're telling the truth, then that'll stay consistent through. But if you tip your hand beforehand and they know what's coming, then they can prepare for it. If you think of trial as a last resort, then you can give up a hugely significant strategic advantage that you have as the defense in a criminal case that nobody else has. So trial is a risk, and it's a big risk, but it can pay off. So it shouldn't be thought of as this thing to be avoided or this avenue only of last resort. If there's a good defense, if there's a person that's facing illegitimate charges, then trial is your biggest and your best weapon in the criminal justice system. And if that's the way that it's going to go, then you shouldn't let these other threats break you down and force you into the wrong plea offer. So that's just my thoughts on that concept. I hope it was helpful. My name is Austin Lux. I'm a criminal defense attorney. I practice in Colorado Springs, Colorado. And I want you to know your rights and know the law.